Some really interesting sound bites from Paula County this afternoon regarding her client and regarding Bob Lee and the autopsy. Things that were said, and I'm paraphrasing here, had a lot to do with the drugs that were in his system. I think at one point she referred to him as the Walmart of recreational drugs. She made some characterizations about people who do drugs and the decisions they make. And I just want to know how, if at all, it seems like it's going to play into her case potentially, how, if at all, does the autopsy results impact your office's case?
So I have not reviewed the autopsy report myself yet. At this time, I will speak hypothetically that we are accustomed as prosecutors to having the reputations of our victims be denigrated by the defense. That is a customary defense tactic that is normal, sadly, in the work that we do. At this point, regardless of whether somebody has or has not done drugs, that does not give someone a license to kill them. And so we are going to continue course with the facts that we know, because we believe that regardless of whatever that toxicology report may show, that Mr. Momeni is guilty of murder.
From a legal standpoint, how much longer can this delay of entering a plea go on, theoretically? Is there any theoretical end to these delays?
Really, there is not. The defense has the ability to continue this arraignment as long as they wish. Mr. Momeni is in custody, and the law views it as though it is his choice whether or not to exercise his rights to a speedy hearing or any other part of this criminal justice process. I really think that this is a learning lesson right now and an opportunity to educate the public on the way that the criminal justice system works. Oftentimes, the DA's office is blamed for cases that age for years in this system without people understanding that we don't have the power as a DA's office, and our victims have no rights to enforce the speed with which a case comes through the system. The defense has that right unilaterally for the most part. And this is a situation where they are exercising their right to delay this until they feel that they want to move forward.
You mentioned the victims' families.
Guys, let's not all shout at once. Let's go Sergio right here, and then we'll go here.
You just mentioned the victims' families. We saw, again, a parade of people going in. Tell me about them and what's that whole bit.
Bob Lee was somebody who was loved tremendously by his family and by his friends, and they have committed themselves to being present at each and every hearing of this case. They were here for the last court date. I expect they will be here for the next court date as they wait for justice to be pursued in this case. I think, again, it's a testament to what victims have to endure in this system, that they have to simply be at the beg and call of the court unless and until the defense chooses to move forward.
And just a follow-up to the delays, how typical or atypical is this sort of long delay?
Delays are very typical by the defense. Normally, we don't see this level of a delay pre-arraignment. Normally, it's post-arraignment, but this is normal. And so what oftentimes happens is that even after arraignment, they have the right to waive their speedy hearing rights for the preliminary hearing. And sometimes it takes years for us to be able to put in those hearings and ultimately make it to trial. And so we will have to see what timeline they proceed on at the point at which this case goes forward.
Paula County had said that...
Wait, guys. Let's try to be orderly here. We're going to go here. I can see you, but we're going to go here first. Then we'll go to Annie, and then we'll come back to you. You haven't asked a question, and then we'll do you guys. And that's a lot to remember, but I do remember.
Thanks so much. What's your strategy with regards to a motion to detain, and what are your comments with Paula Cannion's very confident not guilty plea?
We are proceeding with our motion to detain at the point at which we can. Right now, obviously, the judge has granted it without prejudice. That simply means it's granted temporarily until the time that the defense chooses to argue that motion. They can choose to argue it at arraignment. They can choose to argue it sometime after. It's really, the ball is in their court in that regard. We maintain that we believe he is both a flight risk and a public safety risk. And so that is, we will offer more facts if we believe that the court needs additional information, but at this time we believe we've provided them with sufficient information.
So is there a change in strategy in prosecuting the suspect because of the autopsy report with all the drugs that was shown?
Again, I have not reviewed the autopsy report. I cannot confirm or deny anything that you all have received. Hypothetically, what I will say is, at this point, I don't believe that any drugs being present or not being present play any part in what happened here. I don't, at this point, see it as something significant.
Thank you, Mindy. Can you shed any more light, given a lot of rumors out there, on a motive in this case, and a follow-up, because we are talking about delays, if there's been any movement in the Don Carmignani incident?
At this time, we are not offering any more about the facts of this case. Again, ongoing investigation. We have to protect this prosecution. We owe it to this family to be able to deliver them justice. And so we've offered everything that we are going to at this time. With respect to the other case, right now, you all know, I make myself available anytime you need me, but I want to make sure we simply focus on Bob Lee at this moment in time.
The autopsy. Last time we saw you, you said up to 60 days. I reached out to the medical examiner's office right after I talked to you, and medical examiner's office said up to 90 days, and that was the national standard. Paula County last time said it takes forever, and she was waiting for that. Now we have it. We got it last night, and downstairs she said she's never seen an autopsy done this quickly, and she also made note that the media received it before she did, and I think before your office potentially did as well. Did something unusual happen here with this autopsy report, either in how quickly it got done or who it was released to first?
I can't offer any information on either question, really. The medical examiners have the ability to complete their reports when they do. I have no information regarding the speed with which they decided to pursue this particular autopsy. We did not ask them to expedite this in any way, is my understanding, and so that's simply a product of their choice. As to how the press came into possession of it, that is something that I am also unaware of. It does appear that it was provided to you before it was provided to us, and that's something that we will have to look into.
Does that bother you?
Absolutely, it bothers me. There is appropriateness in the way that we handle these cases. This is someone who was killed. He has a family, he has children who should not have to learn of these things through the press. They have rights to privacy. And again, we should be making sure that there's a certain level of decorum in the way that we handle these types of sensitive cases.
So the next hearing is going to be an arraignment. Is it also going to be like a hearing for detention? And if so, what does that play out like? I mean, is there going to be arguments and evidence as part of that?
As I've said earlier, the defense can choose when they argue the motion to detain. Normally, that is something that is often argued at the time of arraignment, but sometimes in more serious cases like this, the defense chooses to put that off until after the preliminary hearing and a judge has been able to hear more about the facts and circumstances of an incident. Ms. Canny will have the right to choose on behalf of her client whether they want to proceed with those arguments at arraignment or sometime after. Whenever we argue the motion to detain, yes, there will be vigorous arguments on both sides. I expect Ms. Canny to argue why her client is not a flight risk and why he is someone who is not a public safety risk, and we will counter those arguments with the facts and evidence that we have. But that's the way that normally goes.
You said you have not seen the autopsy. Have you reviewed or are you aware of the toxicology report?
I have not reviewed either, no.
Can we go here?
Does the prosecution, when Momeni got arrested, does the police run a test on what to see if he was on drugs as well, or is that something that just his attorney will know?
So it depends on the situation. So what we normally look for is how soon a suspect is arrested after an incident. So if it's at a time proximate or close to the time of an incident, it's more relevant whether we test them for narcotics or other substances. Mr. Momeni was arrested 9 days after this incident, and so we will not be able to necessarily see what was going on with him at that time. As time passes, that becomes something that's more compromised.
The three unnamed witnesses, were they using drugs at the time?
I'm not going to offer any more facts at this time with respect to the case.
Joel?
Two quick questions. You were ready to go with an arraignment today if Pollock County was? Is that accurate?
Yes, we were absolutely ready to proceed today had the defense wanted to proceed.
And so she's delaying for her reasons. Does the delay then give you time to build your case? Does it, I mean, understood you wanted to go today, but in the meantime, does it help you to strengthen your case?
It certainly can work out that way in certain cases. This was, yes, a very much ongoing investigation, and so as evidence continues to come in, while this is being delayed, it does provide us with more that we potentially can proffer to the court at a preliminary hearing. So yes, it could have its advantages to us as well.
Thank you.
All right.
Oh,
I think we got
guys
it.
ran out, okay.
Thank you.
Thank you very much. Thank you.
I see that.